Look, now as we transition from 2025 to 2026, SABC reporters across the country engaged many South Africans in their festive moods about what their goals and plans are for the year 2026. And to my surprise, many South Africans said that they want to get married. Now, marriage isn't just about love. It has legal implications that can affect your future, from customary marriages and lobola traditions to the advantages and risk of different regimes and contracts. Now, it's important for you to understand this. Because many of you want to get married, I thought we need to have this conversation. So we brought in Yolanda Mnyengeza, who's an attorney at Mnyengeza Attorneys Inc in Gauteng, an expert in family law, trusts and estates. Yolanda, good morning. Thank you so much for your time. Really do appreciate it. Yolanda, where do we get it wrong? What are some of the key questions that couples need to ask themselves before they sign on the dotted line or before those lobola negotiations begin?
All right. Hi, Oliver, again, and hi to your listeners. Listen, Oliver, unfortunately, we just have to put it out there that a lot of people do not go through these discussions prior to getting married. And this is the biggest issue that we have. So people, the first thing that they need to be doing is to having this discussion with their legal practitioners so that they can understand the type of marriage that will work for them. But then the questions that people should ask themselves are, one, what are the financial implications of us getting married, and how are we planning to manage our finances? Do we run something like a business, and how are we going to run it going forward? How will it affect our marriages if it were to fail tomorrow, right? And thirdly, what type of family are we trying to have here? How will that affect us? Do we have extramarital children? How are we going to take care of these children outside of this marriage? Even if it's the children that we have already, how will that operate? All of these questions will guide people into determining the type of marriage that will work for them. So often people expect that this is a blanket approach where we can just simply say, just go for a marriage out of community of property. Unfortunately, it's something that needs to be befitting for your own family. So which is why you need to go through this inquiry with your own legal practitioner. That way, you can get clarity as to the type of marriage that will be suitable for your own family.
Yeah, let's talk through those different types of regimes that exist for couples to consider. Now, there's marriage and community of property, and of course, there are considerations around accrual, non-accrual. Talk us through the various options there.
Okay, so we have three different types of marriages in South Africa. The first one being the default marriage, which is a marriage in community of property. Now, with this type of marriage, what you're essentially saying as a couple is that we are going to share in everything that we're bringing into this marriage and that we're going to build in this marriage, meaning that we're going to join our debt together. Everything that we build in the form of financial assets, it's going to be owned by us equally, irrespective of what one of us is going to bring into this marriage, right? We are going to share things like your pension funds, etc. And also, if the marriage comes to an end, we are willing to share this on an equal footing. But this essentially means that because you guys are one, the kind of things that you can do are limited on your own because you have the ability to affect your spouse. So which means that in some instances, you're going to need the consent of your spouse in order to enter into certain transactions. Then we've got two other marriages, which are the marriages out of community of property. We've got the one with accrual, then we've got the one without accrual. Now, the one without accrual essentially states that you guys are saying that you want to keep your lives separate. I want to be able to take out debt without having to reach out to you as a spouse. I want to be able to transact as much as I want to, sell my properties if I want to. So there is nothing that ever comes together between the two of you. If you inherit anything, it belongs to you. And that's how it's also treated when you guys also separate at divorce. There is no intertwining of assets. Then this brings us to the last type of marriage, the one that is out of community of property with accrual. Now, with this one, essentially, it looks as though it's the one without accrual, right? But what the both of you are saying is we are willing to share in the things that we build in the marriage. For example, if we have or attain a growth in the financial assets that we have, what we're essentially saying is at the end of this marriage, whether by death or divorce, we would like to share in that growth together. So meaning that whoever has a lower growth will then have the ability to share from the financial assets or the growth of the spouse that has had a bigger growth. So in a nutshell, those are the types of marriages that we have in South Africa.
Yeah. Now, of course, a lot of South Africans get married through customary marriages, which have its own legal considerations and legal implications. What are important legal effects for couples to consider if their first instance, or at least the first time they get married, would be not in a court of law, but would be customarily?
So I think the most important one, which also the government has been speaking on, is the issue of registration. So if you'll note, Oliver, a lot of people get married in terms of custom, but they do not register these marriages. This is a big problem because in the future there is uncertainty, and there's a need, therefore, for people to fight to prove that there was an existence of a marriage. So that's the first consideration that has to come to mind, that if you are intending on getting married in terms of custom, as soon as you're married, make it a point that you go and register that marriage. Then it's going to safeguard your interests as the parties in this marriage. And also something to consider is that you should not do the practice or try and get married in this manner without getting proper legal advice. Because often what people have done and what we see them doing on an ongoing basis is that they first go and do the traditional marriage and do the celebrations, and thereafter want to come to legal practitioners and say, can we just fix this thing? I don't think we should be married in community of property automatically. That's not how it works. So these are things that people need to consider prior to even taking any step, in particular, even trying to go and pay somebody's lobola, because that is an important aspect of the customary marriages in South Africa.
Yeah. If you're listening to this conversation and you have some questions or perhaps want to share your experience in negotiating your marriage contract with us, give us a call. The number is on your screen right now, 011 714 0661 or 0662. I'll repeat that number for you and it's on your screen right now. Give us a call, 011 714 0661 or 0662. Yolanda, let's talk about changing a marriage contract. What are the requirements, legally so, for you to meet to be able to change your marriage contract after the fact?
So in terms of the Matrimonial Property Act, in particular, Section 21, the parties have to agree to this change of their marriage contract. So that's the first thing. And the second thing is that anybody who might be prejudiced by this change has to be informed of this idea that the parties now have. For example, if people have debts and let's say substantial debts, anything above 500 Rand, it's required that they need to go and inform those creditors to say, okay, we're going to change our marital regime now, and we are asserting that this is not going to affect you. That gives an opportunity to that service provider to say, hey, let me go there and object, or let me raise my concerns with this because I may just be affected. And then after, it also is required that this becomes published so that everybody's aware of it, published in the Government Gazette and also in a local newspaper, so that the people who may just be affected by this decision that the both of you are trying to make, is they know about it prior to this decision actually being finalized in a court of law. So those are the main things that need to be present for this to be granted.
Yeah, I want us to go back to customary marriages because we learned a very important lesson, and I think the precedent-setting case there was the HHP Lerato case, which made its way all the way to the Constitutional Court, where the Constitutional Court was quite clear that the process of customs need not be completed for it to be deemed a valid marriage. What are the steps at a minimum level that need to be met at the lowest threshold for it to be considered a marriage in common law and in community of property?
So in terms of the recognition of Customary Marriages Act, there are mainly three requirements that must be met for a customary marriage to actually be recognized as such. First things first, these people or these parties that want to get married must be over the age of 18 years of age. And number two, they must consent to each other getting into such a type of marriage. And then the third one, which is often controversial, is that this marriage must be negotiated and celebrated in terms of custom. Now, this means that whatever it is that is done in terms of your custom needs to happen in order for this marriage to be regarded as one which is a marriage in terms of custom. Now, there's a mistake that people make, and that is to believe that only lobola is the determining factor. But that is not the case. What the courts have also said is that we need to look at each different type of custom and determine, based on that custom, what is it that they do in order for a marriage to come into effect. And if in that particular custom only lobola is required, nothing much is required, it may be declared that the marriage is in existence, right? But then again, it doesn't mean, like you have said, that everything needs to have happened to the T. As we are in a constitutional dispensation, things change. As people move away from the rural area, how things are done totally changes. So as long as those three requirements have been met in the eyes of the law, then it will be determined that a customary marriage is in existence.
What does the fulfillment of negotiated look like, and what does the fulfillment of celebrated look like?
That's the trickiest part, Oliver, because in South Africa, we have so many customs. Look at the languages that we have. So each culture celebrates marriage in a different way. In a certain, like I said, in a different culture, only lobola is a necessity. But with other cultures, there's also a handing over, etc. So this is necessarily an inquiry that must be done by the court if this is a question before the court, so that they can determine whether in terms of that culture, at least a negotiation and a celebration was done. So unfortunately, we don't have a specific way which we can determine that, okay, it has been negotiated and celebrated.
Yeah, and of course, that would be judged on the merit of each case. Yolanda, we're going to have to leave it there. Thank you so much for that really insightful conversation. Yolanda Mnyengeza is an attorney advising us there on marriage contracts and family law.